you. I'm going to go ahead and call your case. This is the final case of today's case call. It is People versus Gregory Washington. It's a mini oral argument on the application. That means you each have 15 minutes. Mr. Royal, you may try to reserve some of that for rebuttal, but we ask you to manage that on your own, and you may proceed.
Thank you, Chief Justice McCormack, and thank you all the justices of the Michigan Supreme Court. My name is John Royal. I'm the attorney representing the appellant Gregory Washington in this matter, and we greatly appreciate the opportunity to address you at this time with respect to the important issues raised in our application. The court, as you know, remanded this matter for us to address two issues in supplemental briefs, which we have done, and I asked the court to consider our arguments in granting the relief that Mr. Washington seeks. The first issue that we were asked to address is whether or not the circuit court, in resentencing Mr. Washington while his application for leave to appeal was pending in this court, constituted a defect in subject matter jurisdiction. It's our contention that it does. The court rule, the applicable court rule states that proceedings on remand are stayed once an application for leave to appeal is filed in this court. And there's no question, there's no dispute that that in fact happened, and that in fact the Judge Fassard purported to act to resentence Mr. Washington during a time when the proceedings were stayed and she had no authority or power to act. Because she had no authority or power to act, it's our contention she had no jurisdiction over this matter. This court initially addressed the issue of jurisdiction back in 1847 in Palmer versus Oakley, when it said that the power to hear and determine a cause is jurisdiction. And that is a definition that has been adhered to by this court and by the federal courts ever since that time. Most recently in 2002, the United States Supreme Court in United States versus Cotton said that because subject matter jurisdiction involves a court's power to hear a case, it can never be forfeited or waived. It's our contention that that principle applies here in these circumstances. And I forgot to indicate at the beginning, I do intend to preserve 3 minutes for rebuttal.
Well, why don't I interrupt you then and just see who has questions for you so you can have some chance at succeeding in that goal. And I will start with Justice Welch.
No questions.
Justice Zahra.
No questions at this time, thank you.
Justice Viviano.
No questions.
Justice Bernstein.
Hey, thank you. No questions.
Justice Clement.
No questions.
Justice Cavanagh.
None for me.
Well, counsel, let me try one. This is an interesting case because I think that our precedent in George supports your position that the trial court did not have subject matter jurisdiction when it resentenced your client. But if you succeed, what your client wins is the right to be resentenced again, right? It's not that's what's at stake here. Is that correct?
Well, one of our contentions is that the resentencing that occurred in October 2006 was void, and that all proceedings, we put that in our reply brief, in our supplemental brief. So our position is that all proceedings since that time have been void. So this would really be simply a motion that Mr. Washington filed to ask the circuit court to comply with the Court of Appeals directive in 2006 that he be resentenced.
So is that a long way of saying I might be right that what would happen is he would be resentenced if you were to prevail?
I'm sorry, that's the relief we're seeking, is that he be resentenced, correct?
Yes, okay. So, obviously subject matter jurisdiction is jurisdictional, so we don't have a harmless error test, but if there ever were a candidate for one, it sort of feels like this might be it. Address for me the the sort of the fact that all your client would get is what he already got. And so this feels like a lot of time in for that particular relief.
Well, I think that brings into play the court's original order remanding this case for reconsideration by the Court of Appeals in light of the Luscombe decision. And in that case, the court determined ultimately that the action of the circuit court was harmless because at the time the circuit court tried the case, the only thing that had not occurred was the ministerial act of sending the record back to the circuit court. The time to file an application for leave to appeal in this court had expired. In both George and in People versus Swafford and in the instant case, the application for leave to appeal had been filed timely in this court, was pending, and whatever happened in the circuit court was going to depend upon the decision of this court, whether it denied the application or granted some type of relief. So our position is that the circuit court does not have jurisdiction to proceed when there's something timely filed pending in this court that could result the outcome of the case and result the actions that the circuit court is required or has the option of proceeding with. That's the difference. And that's why we believe George is the appropriate precedent in People versus Swafford and not the Luscombe case.
Thank you. You may proceed. You still have some time left, or you may reserve. Up to you.
Okay, I'll reserve the rest of my argument.
Okay. Mr. Schaap, you may proceed.
Thank you. Good afternoon. May it please the court. My name is Joseph Schaap, P81256, appearing on behalf of the appellee, the people. The Court of Appeals' latest published opinion in this case provided some much needed clarity to the bench and bar. First, the Court of Appeals clarified, as this court has attempted to do on many prior occasions, that while the word jurisdiction has been imprecisely used in the past, a vast difference in fact exists between proceedings conducted in want of jurisdiction and those mere errors that are committed sometimes during the court's exercise of its jurisdiction. Second, the Court of Appeals clarified that the existence of subject matter jurisdiction cannot be affected by the underlying facts of a case or its procedural history. Rather, subject matter jurisdiction is a question of the allegations in the case, whether the case at hand belongs to a class of cases that a court is permitted to adjudicate. Third, the Court of Appeals implemented this court's oft-stated policy that divestiture of circuit court jurisdiction is a very serious matter which should only be effectuated if the language of a provision purporting to divest jurisdiction is unmistakable. Thus, the three court rules at issue here, MCRs 7.208, 7.215, and 7.305, do not divest the circuit court of subject matter jurisdiction by implication. They merely, in the words of the U.S. Supreme Court, set inflexible claim processing rules that are subject to waiver and forfeiture. Finally, even if this court believes that a subject or a defect in subject matter jurisdiction actually existed in this case at the time defendant was resentenced, this court should still reassert its constitutional authority to establish rules of practice and procedure by reiterating that under the plain terms of MCR 6.501, convictions and sentences no longer subject to direct appellate review may be reviewed only in accordance with the provisions of the 6500 rules. In other words, MCR 6.501 means exactly what it says. Criminal cases no longer subject to direct appellate review may only be reviewed in accordance with the 6500 rules, no matter how significant or meritorious some other claim might seem to a circuit court judge. Moreover, under MCR 6.502G, no matter how compelling a judge may find a claim underlying a defendant's successive motion for relief from judgment, the claim simply cannot be considered unless it is based on a retroactive change in law occurring after the first motion or a claim of new evidence that was not discovered before the first motion. Therefore, defendant's jurisdictional claim in this case is clearly barred, and the circuit court erred in considering it at all. I would be happy to answer the court's questions at this time.
Thank you, Mr. Schaap. I will start with Justice Welch.
No questions.
Justice Zahra.
No questions, thank you.
Justice Viviano.
No questions. Thank you, counsel.
Justice Bernstein.
Hey, counsel, I want to follow up a little bit on what the chief was asking, but I want to ask it from kind of your perspective, which is, ultimately at the end of the day, there's not going to be much of a change that's going to happen as it pertains to the sentencing. I would imagine the outcome is going to be pretty much similar. So I guess my question is, what is it that you're concerned about? What is it that makes this case of importance to the state?
So there's a couple things I'd like to mention. First of all, there is some harm whenever this court orders a remand for retrial or even resentencing. Most especially all the family members of the victim in this case, Mr. Scott. Obviously, they still feel the effect of defendant's crimes all these years later. It's nearly been 2 decades since he was unfortunately murdered by defendant. They've stayed in touch with the prosecutor's office to ensure justice is done in this case. And if this court were to order a resentencing, they would again need to go through, obviously, an emotionally grueling resentencing hearing where they'd be forced to provide victim impact statements to the circuit court again for a 3rd time, almost 2 decades after the murder took place. In addition to that, the Department of Corrections would incur some costs. They would have to create a new pre-sentence report and, of course, transport defendant to the circuit court and back from prison. The circuit court and the prosecutor's office would both have to prepare for the resentencing hearing nearly 2 decades after it took place. They'd have to refamiliarize themselves with the case. And I also think it's important to note that there would be effects in future cases that would result from this court's ruling. Perhaps the most important of these would be a double jeopardy issue. The United States Supreme Court has indicated on at least 4 occasions that I'm aware of that a conviction or even an acquittal that is obtained from a court without subject matter jurisdiction over that particular case does not bar a subsequent prosecution for the same charges because the defendant was never actually put in jeopardy for purposes of the double jeopardy clause. Under defendant's theory of the case, then, if the Court of Appeals had remanded this case for retrial rather than resentencing, and the trial court had presided over a new trial while an application was pending in this court rather than presiding over a resentencing, the result of that trial would be null and void, even if it was an acquittal, and a zealous prosecutor could, in theory, they would be entitled to charge defendant and bring him to trial a 2nd time for the same offenses. So I think these timing errors, thankfully, are rare, but they do occur, and I think it's evidenced by the fact that 3 prisoners have filed amicus briefs in this case, and by my count, this court's first order in this case, along with the 2 published Court of Appeals opinions, have been cited by Michigan courts no less than 6 times in the few years that they've existed. So while these timing errors are thankfully not super common, they do occur, and they could have serious effects on future cases and this case if this court has defined a defect in subject matter jurisdiction.
Counsel, thank you.
Thank you.
Justice Clement.
No questions. Thank you.
Justice Cavanagh.
Yeah, I just have a couple. So picking up on your last point about, the potential danger of voiding a retrial if the trial court proceeds, and that these could be sort of serious consequences. Isn't that the point of why we have rules in place that you shouldn't have cases pending in 2 courts at the same time, that the right to ensure the right to appellate review? Yes, I could see it's a harsh consequence perhaps if a retrial goes on in the trial court when that issue or that judgment is still being reviewed on appeal, but that's because it's a really important thing that trial courts don't proceed on matters that are being reviewed by appellate courts. Isn't that right?
I don't disagree in theory with anything you're saying, Your Honor. I think the important distinction in this case is its procedural standing at this point. If defendant had objected at the 2006 resentencing hearing to the hearing being held and stated, there's an application pending, this is not a timely proceeding, then he would have been entitled to appeal that. Even if the circuit court had denied the objection, he would be entitled to appeal that on direct appeal and presumably get a resentencing. But here, defendant did not object, and he also did not raise it on direct appeal or in his first motion for relief from judgment. So the idea then is the interest and finality of these proceedings is at a paramount level on a successive motion for relief from judgment. Of course, when reversible error does occur, then sometimes costs need to be incurred by the parties and the court. That's of course true. But
Okay.
what constitutes reversible error changes based on when the objection is raised, whether it be direct appeal, a first motion for relief from judgment, or a successive motion for relief from judgment.
Okay, and I have to say, like, I don't take sort of lightly this idea of preserving appellate jurisdiction, right? I think it's a very, it is up there. It is, as weighty as things like subject matter jurisdiction and that. And if the Constitution and then the legislature have given or have said that the circuit court's jurisdiction is prescribed by or can be prescribed by rules promulgated by our court. And I know, and I don't disagree with you that if our rules are going to circumscribe the jurisdiction of the circuit court, particularly when we're talking about when jurisdiction may transfer to an appellate court for review of a circuit court order, that those rules should be clear, right? And I guess what I disagree with, and I'm wondering if you could help me think about this differently, is that I read the rules as being fairly clear, and I'm wondering what you would suggest would make them more clear if you say that they're not. For example, I read 203, that filing in the Court of Appeals is jurisdictional. 7.208 makes very clear that once a claim of appeal is filed, a trial court may not amend a judgment unless in very specific circumstances. It starts with the Court of Appeals, and then that judgment of the Court of Appeals is not effective until the Supreme Court has passed on it or the time has expired for that. So given that progression of filing through your claim of appeal in the Court of Appeals all the way through to our court finally deciding on a pending application, what would make it more clear in our court rules that the circuit court is divested of jurisdiction and that jurisdiction has transferred to the appellate courts? What would make it, what type of a rule or which rule in particular would make it more clear that our rules are in fact circumscribing the Court of Appeals jurisdiction?
So I would agree that the rules are clear insofar that they prescribe timing rules, or in the words of the U.S. Supreme Court, inflexible claims processing rules. What is not clear is that these rules are jurisdictional in nature. I believe it's 7.215 says that the Court of Appeals judgment is quote unquote effective. So if the court had stated in promulgating the rule, subject matter jurisdiction is hereby divested while an application is pending, then obviously that would be clear.
203 and 204 that says the time limits for filing an appeal of right or an app for leave is jurisdictional.
I believe that's referring to the jurisdiction of the Court of Appeals, not the circuit court.
Well, sure. But that's how they're going to be, in particular in most cases, and in this case, the transfer of jurisdiction to appellate jurisdiction starts in the Court of Appeals, and the rules then progress through to when the final, appellate review through our court is held. So if it's jurisdictional upon the filing of a claim of appeal, and the court rules make clear that a court can't do anything to that order, they're still permitted to do some sort of ancillary orders that don't affect the judgment that's being appealed. How is that supposed to be clear? It's jurisdictional upon filing in the Court of Appeals, as it was in this case.
Well, I think where maybe our disagreement is the idea that if the Court of Appeals has jurisdiction, then the circuit court cannot. it's pretty clear, I think, from the case law that subject matter jurisdiction is a binary proposition. The court either has subject matter jurisdiction or it doesn't. Here, the existence of MCR 7.208, which lists a number of things that the circuit court is permitted to do while an appeal is pending, that rule's existence is contrary to the notion that subject matter jurisdiction does not exist. If subject matter jurisdiction did not exist in the circuit court while an appeal was pending, then presumably the circuit court could not do anything because it has no subject matter jurisdiction. But under MCR 7.2,
Supreme Court, you can prescribe when and when not the circuit court has jurisdiction by your rules, and we say you don't have it over an order once a claim of appeal is filed, circuit court, except in these very limited circumstances. Why are we not allowed to do that?
well, I think, as I stated in my brief, it's questionable as to whether a court rule can divest jurisdiction that has been granted to the circuit court by the Constitution or by statutory authority. There's no real dispute in this case. I don't think defendant even disputes that this case falls in the class of cases, felony prosecutions, that the circuit court has subject matter jurisdiction over as a matter of practice, and it's been that way throughout the history of this state. But even if this court wished to at least attempt to divest the circuit court of subject matter jurisdiction, again, this court's case law makes clear that when there's any doubt, this court will presume that subject matter jurisdiction has not in fact been divested. The court rules that exist at this point do not ever state that the circuit court is divested of subject matter jurisdiction. They merely state that the Court of Appeals gains subject matter jurisdiction upon the filing of a claim of appeal or the granting of an application. And it makes statements such as in MCR 7.215 that the Court of Appeals judgment is effective, and in MCR 7.305 that proceedings are stayed during this court's review of an application, but it never explicitly states that the circuit court is divested of subject matter jurisdiction. So if the court wanted to attempt to do that, I think a clear statement such as that is necessary.
So are there other instances where two courts can have jurisdiction over the same judgment at the same time?
I would say yes. For example, if an interlocutory appeal is filed, jurisdiction is still in the circuit court, assuming proceedings haven't been stayed, and in theory, the circuit court could proceed to trial if a stay hasn't been enacted either on its own accord or by the Court of Appeals. And at the same time, the court
saying that if it's granted, the jurisdiction transfers, right? So it's not in the Court of Appeals jurisdiction until they've actually granted an app. So it's not pending in two at the same time.
I believe it is, and I think it's the nature of subject matter jurisdiction that the Court of Appeals has subject matter jurisdiction to consider applications for leave to appeal, whether they want to grant them or deny them. It's a claims processing rule as far as maybe procedural jurisdiction is the best way to put it. Is the court permitted to act at this moment? But that doesn't mean that it's lost authority over the class of cases of which this particular case is a member. There's just a inflexible claim processing rule insofar as can the court do a certain thing at this time. But in our position is that that's not subject matter jurisdiction.
And just a final question. What if, again, talking about the class of cases, what if we defined the class of cases based on our rules and what the legislature has given us the power to do through court rules to circumscribe the circuit court's jurisdiction? What if we define the class of cases? Does a circuit court have jurisdiction over a final order that has been appealed to an appellate court?
Well, in theory,
ordered felony convictions and sentencing.
Well, in theory, any particular case belongs to any number of classes of cases if you change, or I guess alter what is the class, what is the type of class that you're referring to. In theory, this case would be in the class of cases of defendants with last names starting with W. That's a class of cases. I think in the subject matter jurisdiction,
a little more significant than the initial of their last name.
I agree. I think when the case law talks about class of cases in the terms of subject matter jurisdiction, what they're talking about is what are the allegations in the case. Here, the allegations were that defendant committed felonious conduct, So that is the class of cases that is relevant.
Okay, thank you.
Thank you.
Thank you. Are there any additional questions for Mr. Schwab? We've used up your time, but I want to give any of my colleagues an opportunity if they have one. Thank you, counsel. Mr. Royal, you have some rebuttal time.
Thank you. One of the big disagreements I have with the prosecution position is that their position is that once a defendant is bound over on a felony charge, the circuit court has subject matter jurisdiction forever. The problem is that that means that the language in MCR 6.508D3, referring to jurisdictional defects that could have been raised on appeal or in a prior motion under the subchapter, is surplusage. It could never have any impact. You could never have a jurisdictional issue on appeal because this court has consistently ruled that if a defendant objects to the bind over, they must raise the issue interlocutorily. The court said this in 2003 in People versus Yost and in 1990 in People versus Hall. And if a defendant does not challenge the bind over on a felony charge prior to conviction, the issue is waived. So I don't see how you could ever have a jurisdictional defect to raise even on direct appeal, let alone on a motion for relief from judgment or a successive motion for relief from judgment. But when this court enacted 6.508D3 in 1988, it clearly contemplated that defendants would in times have jurisdictional defects that they would be allowed to raise in a motion for relief from judgment, even if they could have been raised on a prior direct appeal or on a prior motion for relief from judgment. So this court clearly contemplated such relief. And in addition, if you accept the prosecutor's argument, it means a large number of cases by this court have been improperly decided. One of the big ones being People versus Carpentier, which specifically ruled that it was a jurisdictional issue that could be raised on a motion for relief from judgment with respect to the use of improper juvenile convictions to enhance the sentence of someone convicted of a felony. And the court in that case specifically ruled in accordance with federal precedent that this was a jurisdictional challenge that could be raised on a successive motion for relief from judgment, and it was a jurisdictional issue. So if you accept the prosecutor's limited meaning of the word jurisdiction, you are essentially overruling a large number of cases that this court has previously properly decided. Secondly, I want to get back to the issue that I raised in my reply brief, which is that if you accept the logic of two recent cases of the court, which I do, People versus Akram in 2019 and People versus Starnes in 2020, the proceedings, the purported resentencing by the circuit court in October 2006 was a proceeding that is void. And therefore, Mr. Washington has never been resentenced in accordance with the order of the Court of Appeals in June of 2006. And the motion that he filed in the circuit court should be construed as simply a motion asking the circuit court to comply with the 2006 order of the Court of Appeals and to resentence him. And everything that happened in the meantime was void. And so this is not a motion for relief from judgment at all. It's certainly not a successive motion for relief from judgment. And in both Akram and Starnes, this court held that proceedings that were improperly conducted by the courts below that were void, that the court did not have the authority to proceed on, were void, and therefore they were a nullity. And that's our position as to what happened in this case, that everything that's happened since October 2006 is a nullity, it's void. And Mr. Washington should at this time be allowed to be resentenced in accordance with the decision of the Court of Appeals in June of 2006. So thank you very much for your time and attention. I'm happy to entertain any additional questions that the court might have.
Thank you, Mr. Royal. Does anyone have additional questions for Mr. Royal? Okay, seeing none, the case will be submitted. Thank you both for your presentations. That ends today's case call. We will be back here tomorrow morning at 9:30.